Evan Wolfson, Executive Director of Freedom to Marry and author of Why Marriage Matters, America, Equality, and Gay People's Right to Marry, which was published by Simon & Schuster in 2004. There really were two chapters in my life that kind of laid the foundation for my work today. One was that between college and law school, I was in the Peace Corps. And serving in the Peace Corps in West Africa, I made what was not a particularly profound discovery, but it was profound to me, and it was original to me, although obviously most people already kind of knew it. And that was that living in a small village in West Africa on my own for the first time, dealing with people and so on, and especially coming out to myself as gay and figuring out what that meant in a society where homosexuality was not acknowledged and where there was certainly no open gay identity and so on, I realized that a large part of who you are as a person is shaped by the society that you're in, and that options that are available, ways to think about your life, you are not always able to have, depending on where you live and what time you live and so on. So that, for example, many of the people I met, many of my friends, people in the village and so on, I think had they lived in another country, would have been gay. But because they lived in a society and in circumstances where it simply was not an option for them, whatever their own innate sexual orientation and identity and attractions and desires, their ability to shape an identity around it was simply not there. Again, not a particularly novel discovery, but it was a discovery for me at the age of 21 living in Africa. So when I came back from the Peace Corps with this awareness and understanding and went into law school, I, of course, immersed myself in study of law, but I spent a lot of my time in law school actually figuring out what did it mean to be gay now back in the United States. What was my life as a gay man going to be? And I did a lot of reading and a lot of thinking, and I read the book that changed my life. And that book was by a historian named John Boswell, and it was called Christianity, Social Tolerance, and Homosexuality. And Boswell's book traced the first couple thousand years of Western history, showing how, in essence, society had not always treated gay people the way we treat gay people in our society today, and therefore, because it hadn't always been as bad and as repressed and defined in the same way as it was today, it didn't have to be as defined and repressed as it is today, and therefore could change. As somebody who always has loved history and really reads history all the time, finding that window through history into my own personal feelings and desires, and then being able to meld that to my desire to do something in the world, really reshaped my whole thinking about what I was going to do in my life. Because if this could be changed, it should be changed. And I found that through history. So building on that, and building on this lesson about the way you define yourself being shaped by your society, when it came time at Harvard to write what was called the third-year paper, in essence the dissertation, I chose to write on a topic related to gay people, and I decided I would write about what I called in my paper, in words I would never use today because I don't like the way I use the language, but it was same-sex marriage and morality, the unwritten human rights vision of the Constitution. And in essence, it was a paper arguing, drawing on law, but also on religion, on culture, why gay people should have the freedom to marry, why this was important to fight for, why it was a matter of justice and indeed of constitutional law. So that was in 1983, and this was at a time where no country in the world allowed gay people to marry, where the idea of what was not even yet called domestic partnership had only barely begun being developed. And I, in essence, have been working on the freedom to marry, as I now call it, really ever since. It was those personal experiences in my life, the growing understanding as to how to connect that to my passions for history and for law and for social change, melding the personal with the political, and having the opportunity to then synthesize that into a paper that laid the foundation for organizing my thinking on it, that launched me into the work today. One of my favorite quotes years later from a law professor in a newspaper article that did a profile on me, they went back and dug out and found the professor who was the advisor to the paper. And he was quoted as saying in the paper that it's so refreshing as a law professor to find a student who actually applied something he learned in law school, even though he gave me a B. So I always found that very funny. Well, gay people want the freedom to marry for the same mix of reasons as non-gay people. It's about law as well as about love. It's about emotion as well as about economics. It's about the social meaning of marriage as it is about the spiritual meaning. It's about the practical implications as well as the personal meanings in people's life. Not everybody has the same mix of reasons for wanting it, and not all gay people have the same mix. But as a whole, gay people in general have the same needs and the same aspirations and the same desires as our non-gay brothers and sisters. In our society, as in virtually every human society that's ever existed, the institution of marriage, although it's differed widely from society to society, virtually every society has had one, and marriage is the legal institution, the cultural institution, for many the spiritual and religious institution, and indeed the language in which we define and talk about love and commitment and dedication and self-sacrifice, and then award a variety of legal and economic consequences, protections as well as responsibilities. Gay people have the same needs, the same aspirations, the same desires for all of that. So the marriage equality movement, as you called it, is about ending the exclusion of gay couples, couples who have made the same commitment in life to be there for another person, to care for that person, to struggle with the ups and downs of life, to deal with the crises and also the ordinary times. They've made that personal commitment in their life, but they've been denied the commitment in law. That commitment in law is called marriage. And the movement that I'm part of is about ending that exclusion, ending that discrimination. As to what to call it, I actually don't use phrases like gay marriage or same-sex marriage. This is about marriage. There is an institution that exists. It's called marriage. This is about removing a restriction from that institution, removing a barrier and allowing committed couples who otherwise meet the qualifications, who are willing to take on the responsibilities to play by the same rules. Sometimes we do talk about marriage equality. The phrase that I'm most drawn to is actually talking about the freedom to marry or marriage. We don't need a special language. We don't need a special word. We don't need a special term because that conveys the idea that this is about something new and other and usually lesser. We're not talking about that. We're talking about the institution of marriage, an institution that is enduring as well as changeable throughout history, and saying that there should not be an arbitrary exclusion from it for these committed couples simply because they happen to be of the same sex. Well, before I went to work full-time for the gay rights movement, I worked as a prosecutor in the Brooklyn District Attorney's Office. So I did a number of criminal cases, both at the trial and at the appellate level. When they found out, because I came out, that I was gay, and they found out because I came out to them because I wanted to volunteer in my free time to work at Lambda Legal, the gay rights organization, and I wanted to donate my time as a pro bono attorney on weekends and so on. No district attorney had ever tried to do that before, so they had to go through this whole process of deciding was that something you could be allowed to do, and it actually went all the way up to the district attorney, and of course in the process I had to say why I wanted to do it, and I talked about being gay. So as a result, I came out as gay at the workforce. Not that it had been a secret, but now it was an issue, and they were absolutely fine with my doing the pro bono work in my free time with certain rules that were legitimate. And the unintended benefit of that was not only did I get to do the pro bono work for Lambda, which got me involved in writing back before we had computers, so I was writing on little yellow pads in my brownstone on the weekend, briefs that included participation in the Bowers v. Hardwick case, which of course was the terrible Supreme Court case we lost regarding private consensual sex back in 1986, and other important gay rights cases then as a junior attorney. But the Brooklyn DA said, well, if this guy wants to be going out and doing these fancy constitutional cases on his free time, why don't we actually have him doing it for us as well? So as a result, I wound up not only getting to do important and good constitutional work through Lambda Legal, but through the Brooklyn DA's attorney, I was assigned some of the interesting constitutional litigation as well. So I wound up working on the case that actually ended peremptory challenge, race-based peremptory challenges in jury selection in front of the US Supreme Court. And one of the important cases was a case in New York involving a man who had raped his wife and then invoked what was called the marital rape exemption, which was a part of the law at one time of every state saying that a man can't be charged with raping his wife because he's entitled to take what belongs to him. And the Brooklyn DA came in against him, saying he ought to be prosecuted, and there ought to be an ability to prosecute him. And that was an important constitutional litigation that wound up striking down that marital rape exemption, which, believe it or not, still existed in the definition of the law of marriage, even in New York in 1984. So one benefit of coming out was not only did I get to do the work for Lambda Legal, but I also wound up doing constitutional litigation through my main job, my day job, which was the Brooklyn DA's office. After I left the prosecutor's office, I did a stint with the Office of Independent Counsel investigating the Iran-Contra affair, and so I worked on a variety of questions there, and then left there to come back and join Lambda Legal full-time, where I worked for 12 years full-time, having done 5 years of pro bono work. And while at Lambda Legal, I worked on really the range of AIDS and lesbian and gay rights cases. Some of the most interesting ones were challenges to the military discrimination against gay people, seeking parental and custody rights and visitation rights for gay parents, lesbian and gay parents, striking down a deputy sheriff in Florida was fired for being gay. And I went down and actually did Lambda Legal's first jury trial in front of a Florida jury. Very colorful situation. We were actually picketed by the KKK outside the courtroom and wound up overturning his dismissal and winning that case there. But the cases that I'm most known for, and that were, I think, really my most important, were three. One was a case suing the city of New York for failure to provide health benefits to unmarried city workers, and it was called the Gay Teachers case. And we wound up winning that case and requiring New York City to provide health coverage, not simply to married partners, but also to unmarried, both gay and non-gay. So that was a very important case that began paving the way toward, of course, the marriage fight. The other two big cases were the Boy Scout case, where I represented a wonderful man named James Dale, who had been in the Boy Scouts for more than half his life and then was expelled for being gay. We won a unanimous ruling from the New Jersey Supreme Court saying that that violated his rights under the New Jersey Civil Rights Law. The Boy Scouts appealed that to the Supreme Court, and so I became the first Lambda Legal attorney to argue before the US Supreme Court on behalf of James Dale against the Boy Scouts. We actually lost in court. The court ruled 5-4 against James. But I felt always then that we had lost the case but won the cause, because we had really educated the country on the existence of gay young people, including admirable people that really anybody looking at James talking on TV would feel like this is a son they'd be proud of. And people had to rethink their understanding of who gay people are, not as some others outside coming in, but rather young people within every organization, including as bedrock an American institution as the Boy Scouts. And then that was, I think, probably my highest publicity case for most of my time there. And then the other one that was really most significant was the Hawaii marriage case, in which I was co-counsel along with a non-gay man named Dan Foley, based in Hawaii, on behalf of 3 couples in Hawaii who had been denied marriage licenses and sued. And that case led to a trial in 1996 where we, for the first time ever, stood on behalf of couples in front of a judge, having won them the day in court to be able to argue as to what reason did the government have for excluding them from marriage. And we actually won that ruling, the first trial court to rule in favor of same-sex couples, and the judge found that there was no good reason for denying these committed couples the freedom to marry. That case was then appealed to the Hawaii State Supreme Court, where before the court could rule, it was taken away from the court by a constitutional amendment, which set the pattern for some of the events that have followed. So though we didn't win the freedom to marry in Hawaii, we launched the national and even international conversation that has continued about marriage equality ever since. And that's the case that I'm most proud of. Freedom to Marry, my organization, is the gay and non-gay partnership working to win marriage equality nationwide. And the idea of Freedom to Marry is that no one organization is going to be the one-stop marriage shop. No one organization alone is going to be able to end exclusion from marriage nationwide. It's too big. What we needed in our movement, I felt, upon leaving Lambda, was what I used to call the four multis. We needed to understand that the fight was multi-year. It was not going to happen overnight. We couldn't measure success by did we win this month. It was going to have to go for the long haul. It had to be multi-partner, meaning that it had to be able to bring many organizations together, each doing their part. It had to be multi-state, because marriage in the first instance in the United States is regulated by the states. You don't get married by the authority of Congress. You get married by the authority of California, of New York, of Utah. So there were going to be battlefronts in ultimately all 50 states. And it had to be multi-methodology. The work has to be multi-methodology. In other words, we have to have litigation. We have to have legislation and lobbying. We have to have public education and outreach. We have to have organizing and ally recruitment. We have to have funders at the table and involved. We had to find a way to bring all these different methodologies, all these different constituencies, all these different teams in all these different places over a many period of time to be able to work together. And thus it wasn't going to be about one organization, but nevertheless having an organization whose job it would be to help each partner do its part better, to help them communicate with each other. So it's not just a battle in Connecticut, a case in Iowa, a lobbying effort for a law in Washington state, but rather that they're all understood as part of something bigger and larger over this multi-year fight. And being able to then take the work that each of them is doing, the successes they all have, the communication we've been able to achieve, and essentially present it as a whole to new potential allies, new activists, new funders, as something that they could look at as something around a shared strategy that they could be buying the whole, even as they support parts. And Freedom to Marry was designed as a new kind of organization that could work with all the existing, not duplicating or displacing any, but instead making that whole greater than the sum of the parts. And that's the work of Freedom to Marry. Well, since launching Freedom to Marry formally in 2003, the most important change has been that we've won the Freedom to Marry. When I put the idea for the organization forward, I wrote a piece called The Blueprint and published it in The Advocate and said that we could win the Freedom to Marry in at least one state within the next 5 years. And I wrote this in 2001. And people then thought either he's crazy or thought, well, he's right, we're going to win this eventually. But 5 years, that's really pushing it. Of course, we wound up winning the Freedom to Marry first in Canada, not a state, but certainly a close inspiration, in 2003. A few months later, won it in Massachusetts, and went on to win it ultimately in 2008 in 2 more states. So the biggest change since launching this organization is we now have the Freedom to Marry in 2 states. Same-sex couples, as of March 2009, are able to legally marry in 2 states. In several other states, we have won steps toward marriage through measures, whether and mechanisms called civil union or partnership, that although not marriage itself, they're non-marriage marital statuses that have been created in response to the work for the Freedom to Marry to both give and to withhold. They're intended to give many of the protections that the Freedom to Marry fight have clarified needed to be had, but to withhold the full dignity and respect of marriage itself as at least for now. So because of the freedom to marry work, we now have about 6 states that have enacted essentially sweeping, across the board, parallel mechanisms intended to provide many of the protections and responsibilities that come with marriage. And those are states like, I should be able to do this off the top of my head, currently Vermont, New Hampshire, New Jersey, Oregon, who am I missing? The District of Columbia, and as of actually currently, well, it's not official yet, but the Washington State Legislature just began moving this path, and the governor is going to sign it, Washington State, where we have either, and Oregon, where we have either civil union or partnership, but essentially an all but marriage status that has come close to, but not yet fully fulfilled, the freedom to marry itself. Then we have a number of other states, Hawaii, Maine, and there's one other, where we have begun providing some of the protections that come with marriage, although not even yet a full parallel status, a la a civil union or domestic partnership. And then there's a category of states that don't yet have a statewide legal status, whether marriage or something close to marriage, but will honor the status created by other states, or will honor the legal relationships, the most important of which being New York State, where although same-sex couples cannot yet get married at home in New York, if they go to any of the states around New York, Connecticut, Massachusetts, that do have marriage, and come back home married, New York will honor their marriage just as it honors the non-gay couples who get married somewhere else and come back home or do business or work. So the important thing to realize about this is the 2 states that have marriage, Massachusetts and Connecticut, California, where we won the freedom to marry only to have it temporarily taken away, and we will now restore it sooner than people think. The other states that have moved in the direction and are on the verge of shifting from civil union to partnership to marriage. The other states that are beginning their journey, whether by fighting for marriage, as in New York, or by taking a step through civil union partnership to marriage. All of this array of protections and responsibilities and advances and the attainment of marriage itself didn't exist just 10 years ago. So it's an amazing historical shift and accomplishment, with obviously still a huge amount left to do, because 2 out of 50 is not yet good enough. We're not done until we have all 50. At the same time, the right wing has been assiduously working, abetted by the administration over the last 8 years, one of the worst in American history when it came to respect for equality and civil liberties generally, as well as for same-sex couples and gay people, to create an additional layer of discrimination in as many states as they could. So in almost 30 states, there are either constitutional amendments or reinforced anti-gay laws that add to the discrimination that already exists by saying you can't have marriage. No, we really mean you can't have marriage. No, we mean you can't have marriage. In other words, piling law upon measure to reinforce the existing discrimination and the denial of the freedom to marry, as well as, in many cases, to attempt to preclude even the enactment of other mechanisms that are not equal to marriage, but that might provide some protection, such as civil union or partnership or so on. And so the country right now is in what I call in my book, Why Marriage Matters, a patchwork, in which some states are advancing to equality faster, while others resist or even regress. But as I point out in Why Marriage Matters, that's the classic pattern of civil rights advance in America. It always happens that way. In some places it gets worse before it gets better. Some have to go first in order for others to see that the sky doesn't fall and follow. And that's precisely the pattern, the patchwork pattern, that our civil rights struggle is following in the United States as well. Seeking the freedom to marry is not seeking special rights, it's seeking an end to the exclusion from something that most people, gay or non-gay, cherish and value and want to have in their lives. When gay people are allowed to participate in the institution of marriage, there's nothing special about that. It's enabling those couples to have the same opportunities, the same responsibilities, the same rules, the same responsibilities, and the same respect There's nothing special about that. Gay rights are really just non-gay rights made available to everyone. And there's nothing special about seeking to be equal. We live in a country that has as its defining credo the idea that everyone is entitled to be both equal and different. And no one should have to give up his or her difference in order to be treated equally. And that's not a question of special, that's a question of equal. Well, the history of marriage is a history of change. Every society, almost without exception, throughout human history has had some institution called marriage in whatever language the country or society spoke. But they were all very different. What marriage was 2,000 years ago in ancient Rome is very different from the marriage we have today, although many of the elements and even many of the ceremonies we have taken as part of our history. The institution of marriage in the world, in parts of the world today, in Africa and Asia, are different from the way marriage is practiced and regulated in other parts of the world, the West, the United States, and so on. And yet they all have some kind of institution called marriage. And throughout its geographic diversity and throughout its existence in societies over time, there has always been something that's recognizable as marriage and yet very different in its rules, in its responsibilities, in its roles than the way we think of marriage in our society today. In fact, in the United States, confining our look to just our country and thinking about it just over the last few decades, let alone the entire sweep of human history, there have been profound changes in the institution of marriage within our own country, within the lifetime of many of the people watching this film. There have been at least 4 major changes over the last several decades in the institution of marriage here in the United States. We ended the government denial of people's ability to choose for themselves whether to terminate a failed or abusive marriage. We allow people to divorce. We allow people to make that decision for themselves. Changing marriage from what it had been before, a relationship based on compulsion, to a relationship based on choice and commitment, the people's commitment to be there as a matter of their own decision and choice. Another major change, just within our lifetime, just in the United States, has been to end government interference in such important personal questions as whether or not to engage in sex, whether or not to engage in sex without risking a pregnancy, whether or not to engage in sex with the use of contraception. And that important change was fought over on the battleground of marriage. And today, most Americans take it for granted that of course you should be able to use contraceptives, that of course people should be able to decide this for themselves. But when the Supreme Court had to step in to make that ruling in 1965, not back in the Civil War, but in our lifetime, the court based its ruling allowing us to decide for ourselves whether to have sex without risking a pregnancy, thereby decoupling procreation from marriage and from the way it had been regulated before. The Supreme Court based that ruling, that important right to privacy, right to personal freedom decision, in part based on its look at what the institution of marriage meant. And it talked about how marriage is a relationship of bilateral loyalty, of commitment among people, not a relationship through which the government should be propelling some other agenda or through which people should be put at the service of some other cause. It's about the relationship and the decisions and the shaping of life between the couples, between the couple, the people themselves. So this important question of autonomy and choice and reproductive freedom and contraceptive decisions and all of that and sexual and intimacy decisions were all contested on this battleground of marriage and led to this change of decoupling procreation requirements from the decision to be in a marriage. And a third major change that took place in our lifetime was ending race restrictions on who could marry whom. In the lifetime of many of the people hearing this voice and watching this video, it was taken for granted that the government could say that you can't marry the wrong kind of person based on somebody else's thinking. And At times, majorities, huge majorities of people believed that was the right way, and it was defended by the judges, by the politicians, by religious leaders thundering from the pulpit. When the Supreme Court considered the question of whether to end race restrictions on marriage, it was reviewing a lower court judge that had written in defense of a statute prohibiting interracial marriage. The judge in that case had said, Almighty God created the races, black, white, red, yellow, and Malay, and he placed them on separate continents that they might not mix. And but for man's interference with God's divine plan, an interesting way to talk about slavery and bringing people around, these races would be separate, and that's how it needs to be. This was how the race restrictions on marriage were defended. And when the Supreme Court struck those down, in the best named case ever, Loving versus Virginia, that wasn't 1,000 years ago, wasn't 100 years ago, it wasn't even 50 years ago, it was 1967. And when the court made that ruling, more than 70% of the people opposed it. But look how far we've come. So that was the third major change in marriage since just our lifetime. And in the fourth major change, we ended the rules, the so-called definition of marriage that was part of the law that said that women who married men lost legal rights, in fact, lost their legal identity as separate people. That whole Mr. and Mrs. his name thing reflected the law of marriage, which said that they become one, and the one is him, and she should be grateful to be staying in the home and taking care and not being able to have a bank account or own property in her own name and contracts. Well, of course, we changed all of that, and today, most of us think that's laughable. But those changes took place in the 50s, 60s, 70s, and 80s. So marriage has always changed. It's changed in part to reflect people's understanding of people who had been excluded, of people who had been oppressed, who had been denied, but who wanted to participate. And one of the important things to understand about these kinds of legal changes, these kinds of changes in institutions, is that when we change a restriction, when we end an injustice, that is not redefining the institution. It is making it available. It is making it accessible to the people seeking to participate. Women, for decades and decades and decades and decades, were denied the right to be lawyers. And a case even went to the US Supreme Court, which rejected a woman's effort to become a lawyer, to even just get a law license. Well, we kept fighting, we kept battling, and when we eventually ended that exclusion, and women were allowed to become lawyers and practice law, we didn't have to come up with some new word for what that was. Women were lawyers. Lawyers could be women. It didn't redefine what a lawyer was. It ended exclusion. It opened opportunity. And that's what this struggle is about. When gay people participate in marriage, it doesn't change anyone else's marriage. It doesn't redefine the institution. It opens it. It allows people to participate and to have those same rules, those same responsibilities, and that same respect within the institution, which has always been defined as both enduring and changing. People sometimes say to gay people seeking the freedom to marry, why do you have to call it marriage? Why can't you just call it something else, as if there were something else to call it? And it's a good question. It's actually chapter 7 of my book, And Why Marriage Matters, and people do think about it. But here's the answer. The answer is that one of the main protections that comes with marriage is the word marriage. When you say, I'm married to somebody, everyone knows who you are in relationship to the primary person you're building your life with. It's a statement that brings you into a vocabulary of love and commitment and dedication and self-sacrifice that provides security and support in a way that we may take for granted, we may take as automatic, we may not think about, but it is a statement that most people know is so important that they actually wear its symbol on their hand. It is that protection that comes with the word marriage the deprivation of which is actually so harmful and cruel to gay couples, because there is no way to replace that with a bunch of law and a bunch of papers and an attorney and the money that it takes to hire that attorney. If people have to argue about who they are in relationship to their family member, their partner, their lover, their spouse, their husband, their wife, every time they move, every time they cross a state line, every time they deal with another agency, another bureaucrat, if they have to always be fumbling for papers and fumbling for definitions and trying to explain what they are in this legal mechanism thing that people may have vaguely heard of, but that doesn't even have a verb. Did I civil unionize? Did I domestic partner? That's being deprived of something that matters a great deal to people. And people can test that by asking themselves a few questions. One question is, if civil union and partnership are the same as marriage, then why do we need 2 lines at the clerk's office? Why would we be telling some people, you come in the front door, the rest of you go around the back? And if they're not the same, then what is the government withholding? And why should it be able to withhold it? What would the government be saying to those people over here who can get married that it's not saying to these other Americans, these other committed couples who are seeking that same protection, that same meaning, that same security? Do we want the government to be able to withhold whatever it is it's withholding? So people really can't, if they're the same, why do we need 2? And if they're not the same, then it kind of answers itself. One of the protections that is denied by trying to shove people into a separate and other institution is shoving them into something that is, unlike marriage, not a system. In other words, marriage is a system. Everyone knows who it is, what it is, no matter what state they're in, no matter whether they're dealing with the federal government when it comes to Social Security or income tax or when they're traveling. It's a system. Once you're married in one state, you're honored as married everywhere, in every circumstance. And most people can't even remember the last time they ever had to produce even proof that they were married. The power of the thing itself put them in the system that provided security and clarity and dignity and legal protections to them and their loved ones. Civil union, partnership, some of these new legal mechanisms that are being created to both give and withhold as parallel other things for same-sex couples are not a system. And being deprived of that system of protection that offers your family, you, the safety net that you need in times of crisis, and the support that you cherish just in day-to-day activity, is something cruel to deny to gay couples, particularly when there's no good reason for denying it. So civil union and partnership can be good steps in the sense that any provision of legal protection is better than not providing legal protection. But they're no substitute for the freedom to marry and for the security and clarity and dignity that come with marriage itself. America gave 2 great ideas to the world, beginning with our revolution and over the last 200 years. One very profound, important American contribution to world political thought was the idea that here kings don't rule, the people do. And so we decide most questions in life based on votes and based on majority rules, sometimes a larger majority, sometimes a simple majority. But the idea is that we, the people, in most instances, ought to be able to decide for ourselves the laws that govern us as we live our lives together in our precious time on earth. The second, equally important contribution that America made to world political thought was the idea that not everything gets put up for a vote, that there are certain basic rights, certain fundamental freedoms that are so important and so precious to us each one of us, as a matter of our inalienable human rights, that they can't be taken away even by a majority, even by a popular majority against a vulnerable or unpopular minority, even a minority of one. The freedom of speech, the freedom of thought, the freedom of religion, and the freedom to marry, among others. So these two bedrock principles, great American contributions, are things that every American needs to understand. And when we look at the history of our country, what we see is that sometimes the majority, sometimes the politicians, the elected officials who represent us as the majority, make mistakes. I know it may shock people to think that politicians would make mistakes, but sometimes our elected legislators, our governors, our presidents don't get everything right. And so the genius of the American vision was to take these two great principles and create a mechanism that provided checks and balances, a system of preventing abuses against these fundamental freedoms and rights while enabling us to come together and function as a society. One of the most important checks and balances we have in our system is the Constitution itself. The idea that there are certain structures of government and there are certain basic fundamental rights that are enshrined in the law, the supreme law of the Constitution, that can't be taken away or whittled away or ignored at the lesser level of individual laws or individual political actions, even actions that are popular with a temporary majority. Another important check in the system is the idea that no player should be the judge in its own cause, that no one gets to make the final decision on whether it itself did the right thing. The president is checked and balanced by the Congress. The Congress is checked and balanced by the court. By the president, and they're both checked and balanced by the courts. When Congress passes a law, or when state legislatures pass a law, the president or governors can veto them. If the thing becomes a law, there still is a final referee, and that is the courts. And their job is to measure, the court's job is to measure what the elected officials do, what the majority may even want done, against the highest will of the people, which is the will that's put into the Constitution, that says that we don't even want ourselves to be able to override certain basic protections that each one of us cherishes. We, the majority, don't want to be able to take away, we said in the Constitution, the freedom of speech, even for somebody we don't like. We don't want a minority's religion to be subject to the dictates or will, even of the majority. And that fundamental notion of protected individual rights enforced under the Constitution by the courts is what keeps our country free. It's what keeps these two great principles that are the bedrock foundations of democracy, as we understand it, alive for all of us. When the courts fail to do their job, or when they come under pressure to ignore the Constitution, to run away from doing their duty because it's not popular, all of us lose, because we then all become vulnerable to the next wind, the next prejudice, the next passion, the next majority tyranny that might be able to override the individual rights that each one of us has in a society. Gay people have the same interest, the same need, and the same inalienable right to the protection of the Constitution and the protection by the courts, as well as by the elected officials who are supposed to also follow their oath to the Constitution. When the courts fail to strike down discrimination enacted by the majority, the courts are failing to do their job. When politicians attack judges for standing up against even the majority, the politicians are betraying the Constitution because they are pandering to prejudice at the expense of these fundamental American principles. When gay people are denied the equal protection of the law, the requirement in our Constitution, in our system, that says that the majority can't have one kind of treatment for itself that it denies to a minority, that at a minimum, the majority has to treat everyone equally, and if it's going to dish out lumps to one, it has to be willing to take those lumps itself. If that principle is not applied, that principle of equal protection, by the politicians and by the courts, we all lose. This has come into increasing importance in the civil rights struggle of gay people, just as it actually has always been of importance in every civil rights struggle. The whole attack on so-called activist judges didn't begin with gay people. It began in the civil rights era of African Americans, when, after Brown versus Board of Education, billboards were put up saying, "Impeach Earl Warren," the Chief Justice of the Supreme Court, who had written the decision. Many legislators in Congress signed what was called the Manifesto of Massive Resistance, saying that these judges were now tyrants who were trying to force their will on the people, when in fact the judges were enforcing the highest will of the people, the Constitution and the Bill of Rights, that provides equal protection and individual freedoms to all of us. The same thing is true for gay people today. When California allowed a measure to go on the ballot, Proposition 8, to take away a fundamental freedom, the right to marry, and not only to take it away, but to take it away from only one group of people, it betrayed the principle of equal protection and of constitutional rights. And if the court fails to strike that down, we still will win the freedom to marry in California, because public opinion, slowly, bit by bit, as we tell our stories, as people come to understand that there's no good reason for excluding these couples from marriage, hearts and minds open, the younger generation is moving with us, and public support is building for ending this discrimination, and we will restore the freedom to marry in California. But the idea of having to do that by vote is wrong. It's un-American. This is something that should not be put up for a vote, because in America not everything goes to a vote. Fundamental rights, whether you should have free speech, whether you should have freedom of religion, whether you should have the freedom to marry, is not something even a majority should be voting on. It's a matter of bedrock rights and principles, and the Constitution and the courts exist to defend those even when they're unpopular. When the first court in the country struck down race restrictions on who could marry whom, it took almost all of American history to get to that point. From 1776 until 1948, not a single court in the country had the courage to strike that down, to say that interracial couples should be allowed to marry. Finally, in 1948, one court went first by a vote of 4-3, and it was the California Supreme Court. And when the court made that ruling, striking down race restrictions on who could marry whom, 90% of the American people were against it. But the court did its job. It took another 19 years before this question of race restrictions on marriage came again to the United States Supreme Court, which had gotten it wrong previously. And when in 1967 the Supreme Court made its ruling, agreeing with the California Supreme Court, and struck down race restrictions on marriage nationwide, 70% of the public opposed interracial marriage. Now imagine what our country would look like today had those prejudices, that 90% opposition, that 70% opposition, those prejudices of the majority at the time, those passions of the moment over interracial marriage and racial equality, imagine if they had been enshrined in the Constitution then. What would our country look like today? Would our president even have been born? There are just some things Americans have always believed that should not be put up to a vote. And courts and constitutions exist to protect those things for all of us. And all of us includes gay people. If this struggle were just about gay people, it would matter, because gay people are human beings and we're part of families. I have non-gay parents, I have non-gay brothers, I have non-gay nieces and nephews. They love me. They want the best for me, I want the best for them. We're part of communities. We're part of families. We form families. We're human beings. We have what the Vermont Supreme Court called the common humanity that all of us share. So if this were only about gay people, it would matter. But it's not only about gay people. And if this were only about marriage, it would matter, because marriage is a very important institution in our society and a very important choice that people think of as one of the most defining choices they make in their life. Marriage is the language, the vocabulary in which we talk about love and commitment and self-sacrifice and caring for one another. It's the language in which most of us dream of finding a person to build a life with. It's the language in which young people think of their future and the life they hope to have and share with someone precious to them. And marriage is the legal gateway through which we obtain a vast array of protections and responsibilities under law, protections that affect every area of life, from birth to death, with taxes in between. To be denied the freedom to marry, to be denied marriage, to be excluded from marriage, is to be denied all these intangible and tangible meanings that are so important to people. So if this were only about marriage, it would matter. If it were only about gay people, it would matter. But in fact, this is not just about gay people, and it's not just about marriage. This is about what kind of country we're going to have. Is this a country where we believe that the people, each one of us, should have the freedom to pursue happiness, to make our own choices, to shape our own destiny, and to make our own mistakes without the government or somebody else dictating through the weapon of the law how we ought to live? Is this a country where we believe that religious freedom is important, and in order to protect religious freedom, we have to separate the state and the church in order that the government not be taking sides on religious questions, but rather that each one of us be free to decide them for ourselves, to worship in our own way, to believe what we want to believe? Do we want the government dictating who's right and who's wrong on religious questions and imposing it on some of us? Is this a country where we believe in the equality of women and men? Do we really want to be communicating that women are somehow incomplete unless they have a man in their life, that two women cannot, through their own conscience and love, make their own choice as to how to build and shape their destiny together? Is that a decision we want individuals to make, or the government? Non-gay people have as large a stake in these defining questions as gay people do, because these are the defining questions of what kind of country, what kind of community, what kind of society we are going to have. And the fact of the matter is that defining questions like this, the separation of church and state, the equality of men and women, the equality of the races, the question as to who makes decisions in life, the government or the individual, these kinds of important, crucial, defining questions have always been fought out, contested over on the battleground of marriage. Throughout history, marriage has been the terrain on which societies have wrestled with these kinds of crucial questions. And we are met once again on that battlefield. This time it is gay people seeking the ability to participate fully and freely in society on the same terms, with the same responsibilities and the same rules. Whether people individually care about gay people or not, all of us are injured when any of us are excluded or discriminated against. And thus non-gay people have to speak out, just as those of us who are white had a stake and have a stake in racial equality, including ending race discrimination against racial minorities that we may not be part of. All of us are injured when any religious minority or even a religious majority is denied the freedom to worship in their own way, even if we ourselves don't believe what they believe or don't care. All of us, men, are injured when women are downtrodden or excluded or oppressed or limited. You don't have to be part of a group to have a stake in that group. And non-gay people have a stake in how this country, how we, in this time in history, treat all of us amongst us, including gay people. I think most of us would like to think that had we been adults, had we been able to be engaged in the defining battles that shape American history, whether it was standing up for religious minorities, the Jehovah's Witness, Jews facing anti-Semitism, Catholic immigrants to this country, or whether it would be standing up during the 50s and 60s on behalf of racial equality, marching in the South, working to end desegregation in the North. Had we been of age during those battleground times, we would, I think most of us like to think, certainly now, or even people who are older looking back, that we would have spoken out, that we would have done the right thing, that we would not have gone along with the prejudices of the time, we would not have treated people that we saw before us unfairly. And we would not have just acquiesced in the voices that came from the pulpit, that came from politicians, saying that discrimination is okay, that it's necessary, that it's the right thing to do. I think all of us would like to think, certainly with the clarity of looking back and having learned something, that we would have stood up and we would have done the right thing and our consciences would have awakened, and at a crucial moment we would have done our part to make it a better world. Well, we're at another moment like that today. And as Americans, we happen to live in a society where we don't even have the excuse that it's somebody else's fault, because ultimately the government of this country flows from us. We elect the politicians. We create the climate that enables them to rise and do the right thing when they vote, when they lobby, when they work. We are the ones who, by conversations with our neighbors, create the understanding that communicates to our young people, that communicates to our peers, and that communicates to the decision makers that we ought to treat people right, that we ought to stand by American values such as equality and justice and the pursuit of happiness. And if we allow those things to be eroded, if we allow others to treat others wrongly, to discriminate, we're part of the problem. And just as I think we would all like to look back on the epic battles of the 50s and the 60s and the women's struggle for equality, that all of which struggles continue to this day because those struggles are never over, I think we would all like to think with those that we would have done the right thing. Well, 20 years from now, 30 years from now, we should all be thinking now, how do we want to look back on our action today? Did we take action? Did we stand up? Or did we remain silent or acquiescent, or were we part of the problem? And so as Americans, we have a special opportunity and a special obligation to get in there and end discrimination and make this country what we want it to be, and to pass that on to our children, our nieces, our nephews, and the next generation. People sometimes ask, how can they make a difference? How can they do something to end the exclusion of gay people from marriage, or to improve the treatment of gay people generally, or simply to make it a better society? And the answer to that is the recipe for social change is very simple. It's information over time. We have to reach out to the people around us, and you don't have to start with the hardest ones. You work ever outward in concentric circles of closeness. The people in your lives, the people who look to you, the people you can talk with, the people you love and who love you. And whether you're gay or non-gay, you have circles of people who need to hear from you. And you give them the information they need to have. And sometimes that means being willing to push past their discomfort or not wanting to talk about it, to engage them and get them to talk about. The information is very simple. It's why marriage matters. Why is marriage important? How does the denial of marriage affect people, in this case gay people, who are excluded from it? The intangible protections that they're denied, the security, the clarity, the respect, the equality, the opportunity to make a statement about their love and their commitment on equal terms. The tangible denials, the fact that no matter how loved the gay people are in their own community or in their own family, if there's a crisis or an accident, in most states, all but 2 in the country as of today, they are legally strangers to one another. They are second-class citizens deprived of the safety net that is afforded to families in times of crisis and in the ordinary ups and downs through the institution of marriage. So that's the information. Why marriage matters, how gay people really live, what the denial really means, and the fact that just because you're welcome at the Thanksgiving table, just because your partner is treated well, just because people love you or like you, it doesn't mean that you're legally equal. And we need to talk to people and help them understand that. That's the information. And the information over time recipe comes from the fact that sometimes people don't take everything in the first time, or they don't want to hear it the first time. Sometimes people need to hear it more than once. Sometimes people need to hear it 5 times as they wrestle with it in their own consciences. But you can't hear something 5 times if you don't hear it once. So it's important for all of us to not wait for someone else to break the silence, but instead to get in there and have that conversation, to give them the information that will enable them to rise to the better angels of their nature and be fair. Most people want to be fair. Most people are capable of being fair. But if we don't give them the information to rethink, in Lincoln's words, to think anew, then we're not doing our part to help them be the better person they can be, which will enable them to help us end the discrimination we want to see end. And the 2 principles I think people need to follow in giving people information over time are, first of all, we can't assume that just because somebody likes us or loves us or tolerates us or treats our partner well if we're gay or talks generally against prejudice, we can't assume that just because of that they actually understand how the denial of marriage is an injustice, how it harms people. We have to connect the dots and explain that to people and help them understand. And all of the information for doing that is available through websites like freedomtomarry.org or through any of the other organizations that are listed on that website, through books, through pamphlets. People don't have to make this all up. They just need to do a little thinking and prepare themselves to be ready to have conversations with the people in their lives and to break that silence. But don't assume that just because somebody's generally good that they've thought about it or that they understand. It's our job to ask. And the other principle is the flip side of that, which is don't assume that just because somebody isn't with us now, they can't get there. The last several years of this struggle is full of examples of people who initially were skeptical or resistant or even prejudiced or afraid or uncomfortable or believed the kind of scare arguments that the right wing has been putting forward about the terrible things that will happen. But as they, as fair people, have thought about it over time, their hearts and minds have opened and they've changed. It's our job to go out and have these conversations with people and not write them off. And the more we do that, the more we give them that information over time, the more people come to our side, just as they have at every other decisive civil rights moment in American history. But every civil rights moment of change was preceded by a long period of engagement. And I used to go around the country all the time saying there's no marriage without engagement. If we don't engage non-gay people in our lives in a conversation, how can we expect them to understand? We have to break the silence. And the we is not just gay people, because non-gay people can be very effective messengers about why this matters to them as they tell the stories to the people they can reach. And each one of us is the best ambassador, the best messenger to a whole circle of people, better than some lawyer, better than some TV thing. Each one of us is the best person for many people. And it's our job to reach out to them and talk to them. I think there are at least 2 really important points that people need to understand when they think about the question of religion and the question of ending exclusion from marriage. One is that the best way to protect religious freedom is for us to make sure that government is not making this decision, that religions make their own decisions about whom they're going to marry and what their doctrine is. It's really coming to understand the difference between religious rights of marriage, R-I-T-E-S, and the legal right to marry, R-I-G-H-T. Government has no business dictating to religions what their religious rights of marriage should be. It should be up to each religion to decide for itself. But religions should not be dictating to the government who gets to exercise the legal right to marry. Religion should not be dictating, no religion should dictate to any government official who can get a civil marriage license from the government. Now, government doesn't license bar mitzvahs. Government doesn't license communions. Government licenses marriage because marriage is a legal institution that triggers legal and economic responsibilities and rights and protections. And as regards the legal institution, it's important for religious freedom as well as for personal freedom that that be decided under the Constitution through the government, not religion. But the good news is we can have that respect, we can have that separation without it interfering with religious freedom. And people can think of it this way. There are some religions that say, for example, that people should not be allowed to divorce. And if they divorce, they should not be allowed to remarry. Now, the government cannot, in our society, call over to the cardinal and order the cardinal to issue marriage licenses or to perform a marriage for a divorced couple. Government can't do it. But the cardinal should not be able to call over to the government licensing bureau and say, don't issue the marriage license to that Catholic couple or that Jewish couple or that Hindu couple. Two different things. We have this separation in order to protect religious freedom as well as personal freedom. And the legal freedom to marry is separate from the religious ceremonies that each religion is free to decide for itself. So that's one very important point. The second really important point about religion is that when people sometimes talk about religion, when thinking about their position on the freedom to marry, they think about religion in a kind of formal way, but they actually don't think about what their religion really means to them. For most of us, most of the religions that most of us belong to have values and teach values. And those values are almost always important principles like love and treating others as you would want to be treated and judging not that you not be judged and don't put obstacles in the path of your neighbor and respect commitment and show compassion and render unto Caesar what is Caesar's. Leave to the state what belongs to the state and worship as you worship in your place of worship. These are the values that most religions teach, and they are the values that argue strongly for ending legal discrimination when it comes to who gets a civil marriage license from the government. Respecting the freedom to marry under the law in no way forces anyone to change their religious views on religious marriage, but it does fulfill the underlying values that most religions exist to teach.